Within the context of the ongoing legal struggle with the firm, the Securities and Exchange Commission has issued an order that Ripple must pay a fine of $125 million. The Ripple Group is getting set to issue a bond to the United States Securities and Exchange Commission for the amount of $125 million, despite the fact that they are currently engaged in a lengthy regulatory struggle. In spite of the fact that they are currently involved in the conflict, this is the case. The charges that have been made in this action, which has been going on for more than 3 years, have led to the conclusion that the defendant is negligent. Through the release of XRP, Ripple is being accused of participating in an investment offering that is not registered with the appropriate authorities. The imposition of the punishment, which is much less than the almost $2 billion that the SEC had first wanted, is one of the most significant developments in the case that the digital asset industry is keeping a close eye on. The SEC had initially sought about $2 billion. On August 88, 2023, this is one of the most significant changes that the community is concerned about regarding the community. In accordance with an order that was granted by a judge at the federal level, Ripple was forced to pay the assessment, which amounted to a total of $125 million. This ruling has directly resulted in a significant reduction in the initial requests that were made by the Securities and Exchange Commission (SEC). Previous to this, the corporation had expressed its disagreement of a lesser fine, suggesting that a maximum fee of $10 million should be imposed. On the other hand, this is the situation, despite the fact that the corporation had turned down the proposal. Despite the fact that Ripple will still be obliged to pay hefty expenses as a result of the decision made by the court, it is an indication that a resolution that is mutually agreeable has been reached. In July of 2023, Justice Annalisa Torres made a ruling that led to the establishment of this regulation. According to this decision, the rule was established. During that decision, she came to the conclusion that XRP did not constitute an assurance since Ripple had breached securities regulations by promoting XRP to institutional investors. The court came to the conclusion that the firm should be punished for the conduct that it had taken. Nevertheless, the court also found another breach, which looked to be a heated conversation between the parties involved. The cryptocurrency Ripple regarded this as a success to some extent. Nevertheless, the court found yet another infringement of the guidelines. Concerns have been raised in response to the announcement of this decision over the development of a suitable legislative framework for the regulation of Bitcoin. If the Securities and Exchange Commission wishes to file an appeal against the verdict that was handed down by the court, they have until October 6th to do so. On the other hand, it has not adequately communicated what it aims to do. At this exact moment, everyone is debating the question of whether or not the Securities Exchange will challenge the decisions that have been taken. There are some people who believe that this has the potential to start a new constitutional discussion and have an impact on the market for virtual currencies, regardless of whether or not the exchange decides to appeal the verdict. According to Stuart Alderode, the chief legal officer of the corporation, he has stated his belief that an objection is unlikely to have an impact on the outcome, in a more general sense. He has also expressed his confidence in the decision that the court has taken. It has been communicated to him that he is confident in the decision that the court has made. The speaker claimed that such appeals have a poor track record of success, and that the complete study that the legal system does allows little room for new arguments to be brought for consideration. The speaker also reported that similar appeals have a poor track record of success. The individual who was speaking also said that appeals of a similar nature have a short history of being successful. He noted that incentives have the potential to have a large impact, and that the Ripple against SEC case has substantial ramifications for the cryptocurrency business, particularly with regard to the regulation of digital assets. He also acknowledged that the case had significant legal implications. In spite of the fact that this is the situation, he admitted that incentives had the ability to have a substantial impact. There is a possibility that the decision of the court that XRP is not a security, in conjunction with the decrease in the sentence, will have an impact on transactions that involve other cryptocurrencies. The case study offers a greater understanding of the difficulties and ongoing conflicts that are related with crypto limitations in the United States. This insight is offered by better comprehending the obstacles. At the same time as the corporation is getting set to pay the punishment of $125 million, everyone in the industry is seeking for any new information that might be accessible. At the same moment this process is taking place, Ripple Labs has been the topic of a significant amount of discussion over the course of the previous couple of years, with the primary focus being on the likelihood of the business registering for an initial public offering. This exchange took place during the fireside discussion that took place today at Korea Blockchain Week, which is presently being conducted in Seoul. The event for Korea Blockchain Week is currently taking place. an individual who is currently serving in the role of chief executive officer of the organization being discussed. The topic of Ripple in the United States of America was the subject of a lecture that was given by Brad Garlinghouse earlier today. Garlinghouse covered a wide range of issues during his presentation at the conference. One of the topics that he mentioned was the idea of obtaining cash through an initial public offering in the United States. In answer to a query that was posed concerning this subject, the chief executive officer indicated that at this time, they do not have any intentions to go public in the country. The stance that the United States Securities and Exchange Commission takes toward the entire industry, as opposed to simply the industry in question, was another topic of discussion. Additionally, the most of the responsibility for this can be attributed to Ripple. He went so far as to advise that he suggests that persons refrain from incorporating their firms in that location because if they do so, they are essentially asking for more legal fees, which is a position that they are in. Following that, he stated that he strongly advises people to desist from engaging in such behavior. The Securities and Exchange Commission of the United States of America has initiated legal action against Ripple, which is expected to result in damages amounting to several billions of dollars. An appeal has been filed against the lawsuit at this time. The action that is being brought is based on the allegations that the company participated in unregistered placements of securities. These allegations are the basis for the complaint. It is the opinion of the Commission that Ripple's native cryptocurrency, XRP, ought to be subject to the legislation that governs securities. However, this is the opinion of the Commission. The opinion that was held by the Securities and Exchange Commission was partially challenged by a ruling that was given by a judge in the United States named Ana Izay Torres. Through her efforts, she was able to cut the fines by more than 90%, bringing the total cost down to around $25 million. It is essential to take note of the fact that she did not revise her previous decision, which specified that XRP, which is traded on secondary markets, does not meet the criteria for being classified as a security. The individual believes that the name of the company's stablecoin will be Ripple USD. It will also be issued after the Ripple stablecoin has been made available to the public. In August, Crypto Potato issued a report that stated that the name of the company's current stablecoin is Ripple USD. This information was provided by Crypto Potato. It was during the conference that Garlinghouse brought up this subject, and specifics were presented regarding the fact that they are currently in a private beta, as well as the rules that were developed inside this framework. Additionally, according to what they have stated, the launch will take place at the time that it is predicted that it would take place there. Then, the Korea Blockchain Weekend is being held in a few weeks rather than years, and it is slated to take place during that time. In a recent release, the chief executive officer of Ripple, Brad Garlinghouse, indicated that the business is moving closer and closer to the debut of its new stablecoin, which is dubbed Ripple USD. According to their estimates, the launch is anticipated to take place within the next few weeks. In a market where the United States dollar and the United States dollar cash are the dominating currencies, OREST, which has been released and is presently in closed beta, is expected to take place. Will join Ripple's existing XRP stablecoin, believes that this will serve as a viable alternative to the United States dollar and the United States dollar currency, and will include Ripple's own blockchain technology. Both of the blockchain networks that are going to be responsible for making it accessible are going to be different from one another. Ripple has notified everyone that they want to utilize Rust in order to fulfill the criteria of the market. Garlinghouse has informed everyone. Specifically, Gary was the one who brought this information to everyone's attention.